and welcome to TDN Africa Media. I am Amadu Esba, and this is the program Legal Matters, coming to you live on our channel. Today with me in the studio, I have Mr. Emmanuel King, who is going to help me to discuss on the topic of the aftermath that has got to do with the locus in court that the Judiciary of Sierra Leone just concluded in the US last week. So today we're going to talk about that here. If you're just joining us for the first time, Mr. Emmanuel King is a barrister and solicitor of the High Court of Sierra Leone, a legal administrative director for Adonis Mining Coal Limited, the Deputy Secretary General for the National Scrabble Association Sierra Leone, is with us here today. Mr. King, you're highly welcome to the program.
Thanks for having me, Mr. Ba.
Thank you. So we want to talk about the locus in coal. We've started talking about it the last time on the first edition of this particular program. So today we want to talk about it more, especially now that they've finally concluded the locus in coal in the US that has got to do with the Chancery building. So what is the next point of action? If I
okay, so I think we have to lay the premise for the viewers to understand, as a matter of fact, what a locus in court is. So for those who are joining the program today, a locus in court is when the court decides to move to the scene of the crime, or sort of the place which the action arose.
Okay.
Okay, so for instance, now in the instant case of the State versus Sidon and others, in which we see the likes of Dr. Samura Kamara and the other accused persons, the subject matter of this particular cause of action is the renovation of the Chancery building in the United States of America.
Okay.
Okay, so it was renovation initially, then it moved to the stage of reconstruction.
Okay.
So the subject matter of the ACC probe has to do with what happened to the donor funds meant for this particular Chancery building.
Okay.
Okay, so the Chancery building is located in the United States.
Okay.
So now when the court moves from Sierra Leone's jurisdiction to the United States, it's what is called a locus in court. The court moves to the Chancery building in the United States to gather evidence. Okay, visual evidence.
Okay.
That is what is a locus in court.
Okay.
So what precipitates a locus in court?
Okay.
So why would the court not rely on the evidence that has come before it? So these are questions also that we have to answer. We have to get the people to understand.
Okay. So now you just prompted the question, and I'll ask now.
Yes.
What really precipitated the locus in court?
So when there are conflicting assertions before the court, you know, in every trial, whether criminal or civil, all parties will come with witness statements and even documentary evidence, okay, before the court. In this instant case, it is a criminal trial.
Okay.
Okay, so evidence has been led before the court, and it is deemed by the presiding judge that these witness statements are conflicting.
Okay.
Okay, as to the true nature of the subject matter.
Okay.
Okay, so definitely we now have to go and see for ourselves. The court should now move to the place from which the matter arose to be able to get visual evidence, because the evidence that has come before the court is not definitive. You will have one witness say, well, let's just say, for instance, the building is at the 4th floor. Then you'll have another witness and will come to the court and say the building is at the 6th floor.
Okay.
In terms of the reconstruction work that is being done.
Okay.
So if one witness statement says 4th floor and another witness statement says 6th floor, then these are conflicting witness statements before the court. And your witness statements are the evidence that you adduce to the court for the court to rely on for a determination of the matter. Okay. So if the witness statements are conflicting, then the court will now decide, okay, we should go and see for ourselves okay, we should get visual evidence of what this conflicting evidence is about. Let's go and see whether, as a matter of fact, the reconstruction work is at the 4th floor or at the 6th floor. Okay?
Okay. So now, in the case of Saidu Nalo, Dr. Samuel Kamara, and 4 others, now, you would want to ask, the state is the one that is prosecuting them,
yes,
right? In the case of this locus in co, who is sponsoring this particular trip?
Yes, of course, it has to be the state.
Okay.
Yes, because how the locus in co works is that if it was the defense that actually make an application to the court that, well, we want for there to be a locus in co so that the court can now actually move to the place where the cause of action arose, the scene of the crime, then it would be the defense that should take the cost of moving the court to the locus in co. But in this instant case, it was upon the court's volition. Okay?
Yeah, but we saw some few legal practitioners, especially the defense counsel,
yes,
members of the team, said
yes,
they sponsored their own trip.
Yes, so it's a situation where you can now say, the prosecution or the defense can say, you don't have to worry, we can take care of the cost by ourselves.
Okay, but the long and short of it, one who requests for a locus in co,
yes,
sponsors the trip.
Yes, definitely.
Okay, so now there was something very, very significant in that particular locus in co when it was presented live to people. You had the defense counsel saying the building was not supposed to be shown publicly, especially when it has got to do the state matter. And you have the prosecution team saying, no, we think this should be shown to the people. What's your take on that?
Well, I would say generally that there's no rule. There's no rule of law against, or there's no provision of law that has been laid down that when you go to a locus in co visit, it should be televised or not.
Okay.
Yes, so that is a lacuna of the law. So
when you say a lacuna for someone...
Yes, so that is an area for which the law has not provided.
Okay.
Okay, so we usually by practice, legal matters in court are not televised. In practice,
okay,
they are not televised. Okay, especially in this jurisdiction.
Okay.
We now see in advanced jurisdictions of the world like the United States and the Great Britain, they use TV crews and cameras when proceedings are going on. But in this jurisdiction, it is not a usual practice. Okay, but there is actually no position of the law as to whether there should be television crew airing out for the public to see. So,
in other words, the court used its mandate to particularly pass that order, right? And it was, if it was deemed necessary by them, it wasn't the wrong thing to do, right?
Well, I think I have agreed to speak generally to what has happened in the locus in co.
Okay.
So I will assume that it is for public scrutiny.
Okay.
We call it visuals or optics.
Okay.
For the public to actually see what is happening, you know, for the public to come to get an understanding of the action of the court, why the court actually moved to New York, for the public to see the state of the building, you know. I think that's exactly why, but it all has to do with public perception.
Okay.
Yes, it has to do with public perception. So I think in the minds of the prosecution or of the court, they want the public to see the true nature of what has been discussed over the period in courts, in this particular case of the state versus Saidu Nalu and others.
Okay.
Okay, they want the nation, they want everybody to see that this is the building for which the state has spent $4.9 million, and this is the state of the building. Nothing substantial has been done to this building, so they want to gauge public perception. So this is what I would assume.
Okay, in one of the highlights of that particular, what they showed on the television also was the area when one of the main accused, I wouldn't say the main accused, but one of the accused in the person of Dr. Samura Kamara didn't show up in any of the visits to that particular building. And that brought a little bit of mixed feeling in lots of people. And on the other hand, his legal representatives were there. Can you explain why did that really happen? I'm not saying you have to...
Yes, of course. It is a practice of law that in the absence of the accused person, as long as his legal representatives are present, the cause or the matter should proceed.
Okay.
Okay, so they just need to make an application to the court to excuse the accused person, and that's exactly our job, to represent our clients. Okay?
Okay.
So the counsels, the defense counsels, were in a representative capacity of the fourth accused person, who is Dr. Samura Kamara.
Okay.
So his presence was not much needed. I didn't think that they were going to ask him any question with regards the structure of the building. Dr. Samura Kamara is not an engineer. Okay, so he would not know at which stage the reconstruction work is. So he cannot then be a necessary person who should be on the scene. As we would say in our local parlance, pauper, he should be on the scene to make sure that he answers to questions. It was not necessary that his presence was there. As long as his legal representatives were there to see how the process has been done in a very free and fair atmosphere and decorum, then there was nothing wrong.
Okay, so now let's get back to the locus in co proper. What is always the outcome of a locus in co? To start with, what is the defense counsel looking for? Secondly, what is the prosecution witness wanting to prove? And what does the court ascertain from a locus in co? What do they really look for?
Okay, primarily, I have said in passing in my introductory statement that when there are conflicting assertions before the court, the court determines to now go to the scene of the crime to get visual evidence to see for itself the true nature of the thing, the true nature of the immovable thing, because this is not a piece of evidence that we can bring into the court.
Okay.
So we cannot go and take the Chancery building in America and bring it to the court. So the court has to move to the Chancery building in America to get visual evidence of what has come before the court. So now weigh what the witness statements or the evidence that has come before the court is as to the reality of the situation.
Okay.
So we see a situation where witnesses have now come before the court and said a number of things. Okay? So the court, in its wisdom, determines that there is no balance. It's conflicting what these witness statements have said. So we now have to go to, the court should move to the scene of the crime to see for itself and make an assessment of the true nature of the situation. Okay? So after that is done, the judge, well, in our case, it's the registrar of the court, who takes record of everything that is seen on the scene of the offense. Okay? Everything, it takes record. And now comes before, well, at the end of the locus in co, they will now come before the court to proceed. But every single thing that is recorded on the locus in co would now be given into evidence, but you have to swear on oath. It has to be done under oath that this is what we saw when we moved to the scene of the crime. Okay, so it is done under oath so that you do not embellish the evidence, you do not sensationalize the evidence, you do not fine-tune it, you do not change it, you do not add, you do not subtract. Because as long as it is done under oath, you will suffer the pain of perjury if you come before the court and you lie.
Okay.
Yes.
Okay, so lying in the court is what you call
Perjury.
perjury.
Yes.
Okay, so now the courts have returned. According to press statements from the judiciary, every accused person is expected to be here on the 1st of April.
Yes.
What is going to be the next line of action when it comes to the judiciary?
Okay, like many other cases, the court adjourned to be able to proceed to the locus in co, because it is a prerequisite that the court must adjourn to move to the locus in co. Okay, so it is, when it's gone to the locus in co, it is actually conducting a cause of the court while it is there. So it comes back and the matter proceeds. The matter proceeds. I said in the last edition that the prosecution has closed its case. So it is now time for the defense to open their case. Okay? So, yes. So what was found in the locus in co would be sworn to and presented before the court. They would probably do a video, and the registrar will now give in evidence what was recorded in his book or in his camera or on his phone before the court under oath. They will do that. All of that will be taken into evidence. And then the defense will now open their case to say, okay, well, we'll call a few witnesses to come and testify to the innocence of the accused person. We have to take into cognizance that there are 6 defendants, accused persons, in this matter.
Okay.
6 of them. So every single one has a separate defense team. Every single one of them has a separate defense team, which would now come before the court to make a defense for each of these accused persons. Based on
what they've gathered from the locus in co?
On the entirety of the case.
Of the case, okay.
The locus in co is only
part of the
subset of the entire case.
Okay, I see.
Yes, so of the entire case that has been brought before the court, the defense team will now try to put a case forward for each and every one of the accused persons. So I hear many people talking about speedy trial. You know, it is good that the court wants its speedy trial, but it has to take into cognizance that each and every accused person has to mount a sustainable and prudent defense, and that is going to take some time.
So you being a court registrar, you wouldn't want to blame the slowness of the matter on the courts, but based on the matter at hand, right?
Yes, based on the nature of the matter, or on the situation, I should put it that way. Okay, so it is situational that the speed that most people are yearning for in this matter is not going to be the case because there are too many defendants.
Okay, so the more defendants, the more it becomes difficult for the court to just make a decision.
I should also say generally that each defendant has a set of charges that is levied against them.
Okay.
Yes.
Not all of them are carrying the same charges.
No. There is a particular defendant with over 30 counts that he has to answer to. And these counts are not duplicitous, which means they are not the same counts.
Wow.
Yes, so he has to put in a defense for every single count. Every single count that is charged with before the court, he has to defend himself for every single count. He cannot say, I will defend myself up to count 25, and then I leave it at that. The remaining 5 or 6 counts will still send you to jail, or you'll be found culpable. Okay, so you have to put a defense. In the case of Dr. Samuel Kamara, he only has 2 counts.
Okay.
Okay, you have the others. As a matter of fact, Saduna Law is...
Is it the wrong thing to tell the public what the counts of Mr. Dr. Samuel Kamara? Are we prejudiced in the matter if we do that?
Yes, of course, if we do.
Okay, so let's leave that. The program you're watching is Legal Matters, coming to you on TDN Africa Media. And my guest with me in the studio is Mr. Emmanuel King, Esquire. He's here today to help us talk about the aftermath of the locus in co It has got to do with Dr. Samora Kamara, Saidun Alo, and 4 others. We're going for a short break. We'll be back. Welcome back, and if you're just joining us, the program you're watching is Legal Matters, coming to you on TDN Africa Media, and I am here with Mr. Emmanuel King Esquire. Mr. King, welcome again to the program. So we're going to further from where we stopped. So now, having been that the accused persons, 6 accused persons, now need to set themselves free with the findings that they've gathered so far from the locus in co, or from the inception of this particular matter, what will be the expectation of, let's say, the defense counsel and that of the prosecution team, and what is the court expecting at the end of the day? Now that the whole locus in co thing we've done, and I believe the court is supposed to start looking into the matter.
Okay, I have said that at the end of the locus in co, we come back to court.
Mm-hmm.
Okay?
Yeah.
We come back to court, and a recount of what was done, what was seen, what was captured,
mm-hmm.
the inspection that was done of the building will be given in open court under oath. Okay? A clear and concise account of exactly what was seen, what was captured.
So who will be given the account? That's very key.
Yes, so it has to be the registrar of the court or any other witness who was charged with gathering of the evidence on the scene. Okay? Will give an account before the court of what they saw, of what they captured, of the inspection that was done. You will see that one of the defense counsel raised an objection that the technical person of the prosecution, the technical witness of the prosecution, should have been brought to the scene because he was not taken to the scene of the locus in co.
And does that affect that particular investigation?
In his argument, he is of the conviction that the technical person, who is the expert, should have been brought to the scene so that he, as the expert, would have been in a better position to explain to them as to the technicalities of most of the things that they were seeing. In the absence of any expert, they would not have a clear picture that, as a matter of fact, that material that is laying down on the floor should have been in that particular position. The actual or tool nomenclature or name of that particular equipment, which should have been in that particular spot. Because he's a technical person, he knows these things. I'm a lawyer, I'm not an engineer, I'm not an architect, you understand? So I do not have understanding of the technical language of the regime of that particular discipline. So you need someone with that kind of understanding to be able to throw light on some of the things, because it has to do with reconstruction work. And in technical reconstruction work of that nature, engineers and architects are involved. They are the technical people. They know exactly all the fittings and the equipment and every single thing that could have been in place for that building to get to the position where it should have been. You know, so in the absence of that, I think that's exactly why that Defense Council was making that objection.
And from a normal point of view, you can say is on point, but we wouldn't want to prejudice that.
Yes.
But however, in all honesty, and from the law side, why did the courts not call on the experts? Is it that his name wasn't mentioned as a witness in this case?
I would not know. I would not know. I don't know why the court didn't do that. So let's actually move on.
Let's move on.
So as I was saying, now we find ourselves in a position where the court has to come back. We come back to open court, and I think it's the 3rd that the matter was adjourned to. So by next week, everybody should now be in court, and what was gathered from the locals and co will now be sworn to before the court and will be put into evidence. Okay, it will be put into evidence. Well, I would say against the accused persons, because everything that comes into evidence for now is against the accused persons. When they launch their case, everything they bring is to support their innocence, which they have pled to, because nobody among all the accused persons pled guilty to the offenses. They all pled innocent, that they were innocent. So now, at the end of the presentation of the evidence that was found in the locus, then the defense will now open their case, and then every single count will be defended.
So there was this thing about election. We talked about it the last time, for them to testify in the witness box. Is this the time for that?
Well, we've passed the election stage.
No, I know the election stage you've passed,
yes,
and they say they...
I understand what you're asking.
Yeah.
Yes. So at the end of the prosecution's case, the defense made an attempt to do what we call a no-case submission, which failed. All the defendants' no-case submission failed because it was overruled by the presiding judge. And so the accused persons were put to their election as to how the matter should proceed. And they all want to open their defense. Okay? So in the interim, the court decided to, well, the court had decided previously to go to the locals. So they just took this opportunity, because a local should be done anytime before judgment. Okay? Before a determination of the matter, a local should be done. So the court decided that this was the right time. They had enough time now to go for the locals. So they've done the locals. They now have to come back and do a presentation of the locals before the defendants, the defense team, will now open their case to see how best all accused persons will be astutely or stoutly defended.
In the era of speedy recovery, are we going to see that happen, especially now that the locus in co is done?
Yes, when they say speedy trial, it simply means that the court will take every opportunity to make sure that the matter proceeds. Okay? It does not mean that the court will now come to a determination on the matter by its own, on its own volition. No. It has to allow the defense team to make a proper defense for all accused persons. Okay? The court conducts the matter.
Yeah.
Yes. But the defense team would now have to come up with strategies to defend all accused persons. And this would include, among other things, calling witnesses, bringing documents, evidence before the court. And all of this will take time, because it's not one defendant. It is 6 defendants with varying number of counts. By the time we finish with the first accused, the defense of the first accused would have taken, well, this is my estimation, would have taken a whole month. before we come to the defense of the second and the third and the fourth and the fifth and the sixth accused persons.
So basically, we have to keep our eye close to this for like a month. Okay, according to what you think will actually happen.
I say by my estimation.
By your estimation.
It would take like over a month even to just try to make a defense for the first accused person. Before we now start coming to the second, the third, and the fourth, and the fifth accused.
Okay, a lot of people also think for the SEC boss to have published pictures of this particular building without the court having made reports, was almost prejudicing the matter to some point, and they think it was a little bit incriminating to the accused persons.
Well, I have not
How do you react to that?
I have not actually seen pictures of the SEC boss publishing pictures of the building, but we see a situation where the court, even the court by itself, was willing to do a video recording, a live broadcast of the whole process, which means that they want the public to know, they want to gauge public perception of the matter. So I don't think anybody will run into trouble if they start cascading the pictures all over the place, because the court really wants people to see what's happening. Yes.
Okay, because the pictures are all over the place, and lots of people are now, and the reason why we're discussing some of these things, it is for the insights of the last time. What did you say about us that do not really know about the law?
Layman.
The layman. For us, the layman. Now, we would really want to understand the nature of those pictures. You know, we would really want to know the natures of those pictures. Are they as incriminating as people think to the accused persons?
Well, I would not say. I would not say. Well, when in the practice of the law, there are very many technicalities and strategies that people use to win cases, is what I would say. Okay? So, I would not say if the picture would prejudice anybody or anything. We, the people of the general public, are not the ones that will come to a determination of the matter.
Okay.
It is the judge.
Okay. And so for one-to-one talk with Salians, we just need to understand that the pictures does not say the accused are guilty.
The pictures would not prejudice the matter, because the judge who is presiding over the matter actually went to the scene.
Okay.
He saw it all by himself.
Okay.
Okay. He took notes. Okay. He scribbled down carefully what he saw. So, in the final analysis, he would have to come to a determination of the matter based on the evidence before the court. All the evidence before the court. Evidence from the prosecution and evidence from the defense and what have you. That is exactly what the court, the judge would look at. That is what he would look at, not public perception. People will say what they want. You know, people will make a plea, please don't do this, it would cause this if you do this. But all of that will not weigh on the mind of the judge.
Okay.
It is his constitutional mandate to only look at the evidence before the courts to come to a determination of the matter.
Okay, so in the case of, I believe there must be precedents of such cases, right? And that they may have passed judgment on, right? So do we have such kind of precedents, a recent one? Which one would you like to refer to?
Listen,
and what was really the outcome of that particular one?
There have been low costs before.
Okay.
There have been low costs before in this jurisdiction. But every case must be distinguished on its fact, on its own unique set of facts. The low cost that was previously done, the low cost that was previously done was done in the case of Paulo Conte.
Okay.
Yes, the states against Paulo Conte and what have you. Yes, that one is completely different from the set of facts in the case that we are looking at now with the state versus Salunalu and others. Okay, so you cannot use the low cost of that case to determine what would happen in this particular case. And like I have said, the court would not come to a determination of the matter based on the locus in quo.
Okay.
Yes. The evidence that was gotten from the locus in quo now forms part of the body of evidence that is before the court. Okay?
Okay.
So evidence had previously come before the court. What is now gotten from the locus in quo will now add to what was before the court.
Okay.
And then the defense will now make their case to now also add to what is before the court.
Is there specific charges on this particular matter? Specific charges? Because this has got to do with misappropriation of state funds, right? It's one of the cases, right?
That is just one count. Misappropriation is just one count.
And what normally, what's the punishment normally if one is found guilty for such kind?
Well, usually you are fined, you are asked to pay the money back, or you are given a jail sentence. So we have a custodial sentence, and then we have fine.
What's the custodial sentence for the understanding?
Sentence is when they send you to jail.
Oh.
When you are sentenced to
What's the
jail.
maximum? What's the maximum or the minimum jail time?
Well, I cannot say off air with regards misappropriation, but I would say that it has to do the length of how long you would be sentenced would definitely have to do with how much money.
Oh.
Yes.
So at the end of the day, if you've been asked to pay the fine, you definitely have to pay. Is it an option for you to choose?
So it could be an and or both.
Or both?
Yeah, so you could be asked to pay and sent to jail.
What makes it...
Or you'll be asked to pay and not be sent, or you'll be sent to jail and not asked to pay.
Okay, we are not discussing the locus in quo with Samuel Kamara, but we just want to have a clear understanding.
All right,
on
this locus in quo, I need to say quickly.
As in charges and
there
all
are
that.
6 accused persons in this matter.
Okay.
So this is not a locus in quo of Dr. Samuel Kamara. It's not
Agreed.
a locus in
Agreed.
quo.
Agreed.
It is a locus in quo to go to the Chancery building for the court to see for itself, to have visual evidence all by itself. It's what the locus in quo is about. For the court to have evidence by itself. I have said Dr. Samuel Kamara only has 2 count charges. We have other accused persons with
30
plethora of counts. So it's a locus in quo for the court to have evidence as against all these accused persons.
Okay.
Yes.
Okay, agreed. For the sake of the public and those that are watching us now, matters like this, normally, the reason why I mention Dr. Samuel Kamara's name, you already know he's a political figure in Sierra Leone, and his name is very much loud in this whole thing. I'm just understanding that he's only having 2 count charges on this particular matter, of which he needs to put a very stout defense for. But for the understanding of the public, do you think this will affect his political journey in any way?
I don't think I'm legally permitted to say that.
Okay.
But generally, generally, I would speak generally.
Yeah.
That if the court comes to a determination of the matter before the election, and Dr. Samuel Kamara is found guilty of the counts that were leveled against him, then it would be an unfit person to run for public office.
Why?
Because he now has a criminal conviction to his name.
And by the laws of the land, you
cannot hold public office.
So could this not be one of the reasons why people are calling for the speedy trial of this particular matter?
Well, I have said that in law, people use technicalities and different strategies to get to what they actually want. But it is not my place to say that they are actually using these techniques in this particular matter, because if I say so, we will be prejudicing the matter.
Okay, if you're just joining us, the program you're watching is Legal Matters, coming to you on TDN Africa Media. And my guest in the studio with me is Mr. Emmanuel. King, who is helping us to explain the aftermath of the locust in court that the ACC and the Judiciary of Sierra Leone and the defense team for the 6 accused person that of the matter that has got to do with the Chancery building in the UK. We're going for a short break and we'll be back to drop the curtain. Welcome back, and if you're just joining us, this is the program Legal Matters coming to you on TDN Africa Media. I am your host, Amadu Esba, and with me in the studio, I have Mr. King. Mr. King, we're about to bring the curtain down for today's edition. As a legal practitioner, you've been in the legal field. I know inwards there must be something in you that you would want the public to understand about the law. As a parting statement, what would that be?
Okay, when you go to when you go to study law, especially in this country, the very first academic paper that you will write is a question bordering on the law is the law discourse. Okay, so you will be challenged to give your own opinion on that particular statement. What that statement is looking forward to as a student to espouse on is the fact that the laws have been promulgated. They have been written, scribbled down already. They are there. These are the laws of the land. As citizens of the country, as citizens of this land, the general populace, the masses, we have to be compliant with these set standards, these rules, these regulations that are supposed to guide our day-to-day activities, regardless of your opinion of that particular law. So it may be that this law is an onerous law, which means that it's a bad law. It's not actually a good law. It is my advice to you that you should find judicious ways to recommend that this particular bad law is repealed, amended, or expunged from the books. Okay? But as long as it is still the law, you have to comply with it. You have to live under it. Because if not, it will bite you. You will likely go to jail because of infringement of that particular law, or violation of that particular law. Or you'll be fined some hefty sum, or your life will be made inconvenient if you do not comply with the law. So, viewers, the law is the law. Respect the law because it has been promulgated. It is the law of the land. Your duty is only to respect the law. But if it is a bad law, in your opinion, please find legal means to suggest that this particular law is removed or amended. Thank you very much.
Thank you so much, Mr. King, for being on the program with us today.
Yeah, it's my pleasure.
Thank you, viewers, for being part of the program. The program will be Legal Matters, coming to you on TDN Africa Media. We'll be here again on Thursday at the same time. Catch up with us so that you can have insight about the law itself. Stay with us as we'll be back on Monday. Thank you so much. I've been your presenter, Amadu Espa, and I wish you a wonderful day. Bye-bye for now.